And I'm going to start by telling you how I nearly became a hero. It was 1991, and the leader of a very big evangelical church in Natal then, I forget his name, very well-known name, maybe somebody can help me.
Michael Cassidy?
Yes, Michael Cassidy, came down to Cape Town on a special mission to speak to me. And I was a bit curious, and he said, Albie Sachs, would you like to be a hero to millions? Now that's a wonderful offer. So my ears went up. What do I have to do? He said, we're entering into negotiations for a new democratic dispensation in South Africa. And he personally and members of his church think very favorably of these developments. But they have one big concern, and that's why he's speaking to me. Is it possible, could I do something to bring about a preamble that began in humble submission to Almighty God? If you do that, he said, you'll be a hero to millions. And I thought about that. And it was difficult. Not because becoming a hero to millions was within my grasp of my one hand and I might lose it. But I'd grown up in an expressly secular home. Not by accident, not by lapsed religion, not by lack of interest, not by an interest in other things, that the spiritual didn't matter. But my parents took a stand against their parents. It was part of their identification. And they wanted to transform the world, and they wanted human emancipation. And they saw religion as being practiced around them, as being imposed upon them, as expected from them, was a barrier to the kind of liberation they were imagining. And it started when I was very young, aged about 4 in a kindergarten, and my mother asking the principal of the kindergarten, can Albie keep his eyes open during prayers? And the progressive kindergarten head said, of course he could keep his eyes open during prayers. And I kept my eyes open during prayers, and to my amazement, half the other kids also opened their eyes, but they didn't have that permission, and I felt that was very wrong. It became a little tougher. I'm turning 11, 12. The phase of a bar mitzvah is coming, and all my pals at school, half the boys were boys' school were Jews, half were Christian, and they're saying, Albie, when's your barmy, when's your barmy? And I was 2 years younger than any of the others during World War II. A lot of the teachers went up north, the way it was put, the male teachers. Married women weren't allowed to teach then. There was a great shortage of teachers. They pushed us up. So I was very, very young. One by one, my peers, Jewish peers, had their bar mitzvahs, and I'm wondering, what am I going to do? And my parents said, it's up to you. If you want a bar mitzvah, we'll support you. If you don't want a bar mitzvah, we'll support you. And I thought, and it was a very difficult, very personal thought, was if I was to pretend a belief in God that I didn't have as mine, as real, it would be disrespectful to me and disrespectful to God if God exists. And I felt I couldn't go along with that. Now looking back, that's quite tough for 11, 12-year-olds. But the consequence of that is, for me, conscience is number one. Conscience is what in your head. Conscience is what you determine for yourself as the most central aspect of your being. And the paradoxical result of that was fighting for my secular belief system as a young child in an intensely, at least overtly religious, pious environment has made me extremely respectful of, conscientious towards the consciences of others, including religious beliefs and religious consciences. Now that's the preamble to the preamble. One more little important biographical step. Age 17 when I joined the Defiance Unjust Laws campaign, second year law student. And we used to speak on the Grand Parade in Cape Town, sometimes 50 people, sometimes 500, sometimes 5,000. And we're singing songs, volunteers obey the orders, volunteers obey. And it's quite dramatic. And one of the fellow speakers, Johnson Ngobela, who we knew as what we called a big communist, an African man who'd belonged to the Communist Party before it was driven underground, and he worked for an attorney, Sam Khan, who was well known as a communist. And Johnson Ngobela is speaking about one day the Red Sea will open for us like it opened for the people of Israel, and we will be free. I went up to him afterwards and I said, Comrade, I'm using the language of the time, Comrade Johnson, how come that you're using a parable from the Bible in terms of us achieving our freedom? And he said, Comrade Albie, there are some things that politics can reach and there's some things that can't be reached by politics. And it was very meaningful for him. And he was somebody born in the struggle, whose children were in the struggle, they joined the armed struggle, grandchildren active politically, as deeply committed as I ever wanted and pretended to be. And yet for him there was space for politics and for religion. It was all part of his makeup, the way he saw the world. It was one of those shocks that I think everybody should have fairly early on in their life, a shock to a formal philosophical system that you're absolutely certain about, that you will defend with your life. And then it's undermined not through some counter-argument, but by somebody whom you admire and respect, shows that there's another way that's extremely important to them. In any event, I was moved by Michael Cassidy's statement. I didn't see that we could open our Constitution with the phrase, in humble submission to Almighty God. It was just too powerful, too overwhelming. It could have had that constitutional impact and significance of somehow attributing to everything that followed afterwards a certain religiosity, which would be very offensive and very oppressive to people who didn't share in that. And yet at the same time, it was clear to me a great majority of South Africans are religious. If democracy is associated with a form of comfort, of accommodation, of not being threatening to or hostile to or separate from religious beliefs that was so much part and parcel of their lives, especially for African people, but also for Afrikaners, for many English speakers as well, then that would be a gain. It would mean democracy would be more strongly implanted, it would be more welcomed, it would be seen as something more natural for our society, rather than something that lawyers have invented as a sort of compact that's being imposed upon society. And so I was able to make a recommendation when it came to looking at the preamble, not to say in humble submission to Almighty God, right at the beginning, but to say, Nkosi Sikuleli Africa, God bless Africa. We sang it, believers and non-believers alike, Christians, Muslims, Hindus, Jews, atheists, we all sang, Nkosi Sikuleli Africa. And that would be a phrase that would unite us, that would bring us together. It was the hymn of the oppressed. And so the preamble in our Constitution sets out South Africa belongs to all who live in it, and so on and so forth, and it ends up by saying, Nkosi Sikuleli Africa, Morena Beluka Sitraba Sai Su, in Afrikaans, God seën Afrika, God bless Africa. And that was my recommendation, and Cyril Ramaphosa insisted that that's not enough. What about the Venda, Tshivenda, and the Xitsonga, which are not included in the Nguni and the Sotho, and so they added Tshivenda and Xitsonga as well. And it fitted. And what could have been an issue that divided people, that kept us apart, that separated us, was turned around into a theme that brought us closer together. and help to create that sense of unity in diversity or diversity in unity that's foundational to our South African vision. I never went to Michael Cassidy afterwards and claimed my certificate of heroism, but I was glad that he'd spoken to me because he underlined to me the importance of finding a place and a space for religion in our public constitutional order, but one that would not be competitive, jarring, oppressive, imposing, harsh to anybody, but one that would sit naturally into our culture, our history, our sense of identity that would bring us closer together. I'm going to run through briefly 4 cases we had. Now I'm a judge on the Constitutional Court. Before dealing 4 cases rapidly, a little more extensively with the same-sex marriages case that ties in so beautifully with the presentation we had late this afternoon and with the general theme of this conference, the sacred and the secular and the connection between the two. The first case we had on religious freedom in South Africa dealt with a claim by 7-Eleven, the grocery chain, to be able to sell more booze than they were permitted to sell on Sundays, Good Fridays, and Christmas Day. Now that's a hell of a claim for freedom of religion, to sell more liquor on these 3 singled out days. But our law allows you, even if you don't show that you are directly, your rights to religious freedom are directly affected, you can still come to court to say this is a violation of religious freedom because it's singling out 3 religious days associated with Christianity. 4 of my colleagues said, I'm putting it in very non-legal language, come on, this has got nothing to do with freedom of religion. You can pray, you can go to your temples, churches, synagogues, the lot. It's not inhibiting any religious practice. 3 of my colleagues said, no, this is elevating Christianity above other religions. And if you prohibit the sale of liquor on Hindu, on Diwali, and other important sacred days to members of the Hindu faith, on Fridays, although Muslims shouldn't be drinking on any day in the week, on Saturdays for Jews, that would be different. Then they wouldn't be discriminating in favor of one religion or another. I was tending to go with the first. I just couldn't believe the claim of 7-Eleven, come on, it's got nothing to do with religious freedom, it's got everything to do with making money out of selling liquor. And I was going in that direction. I said it's such a trivial form of singling out Christian special days. The law really doesn't want to take account of that. And my colleague, my law clerk, Fatima, the name tells you, Fatima, her eyebrow just went up a little bit. It's the only time I've changed my point of view because of a clerk's eyebrow going up. And I said, Fatima, what's the matter? She said, Albie, and I invited my clerks to call me Albie, by the way. Meant I could make them work harder because they were very familiar. It's these little things that make many of us feel that we are not full citizens of this country. And it made me really realize, although this was a small detail, it was just one of those signals that was coming from the law, that saying that people, particularly Muslims and Hindus, who had come from the Indian subcontinent, who'd been subjected to race discrimination, whose marriages hadn't been recognized, who'd been subordinated in all sorts of different ways. It was a tiny relic, but a relic of a very painful past. You couldn't just say, de minimis, it doesn't matter, it's so small. And so I wrote a separate judgment, and Yvonne Mokgoro joined me in it. And so our two, coupled with the three, made a majority in favor of, well, let me not get there too quickly. Should the law be upheld or struck down? And I asked the question, from whose point of view do you decide whether or not it's infringing religious freedom? From a Christian point of view, where's the problem? From an atheist point of view, well, all religions are equally bizarre. There's nothing special about this. From a Muslim point of view, a Hindu point of view, and clearly it can't be from any particular point of view. It's from the point of view of a believer of any faith or a believer without particular confession, sensitive to the values of the Constitution. That's the kind of question you've got to ask. You've got to imagine yourself, not what you think personally yourself, given your background, but imagine yourself into the position of that ideal type individual. And somebody who is not so thin-skinned that the slightest affront gets your hackles to rise, but not so thick-skinned that you're insensitive to things that can be wounding to others. And that's where, as Advocate Perumal mentioned, I went back to the importance of the way in which the hegemony of Christian values built into the law had an impact on people that denied them their dignity, their sense of self, the significance of their family life, that called their children illegitimate, that said wives were concubines, coupled with the racial discrimination, the ghettos, the go back to India kind of approach. You never told people go back to Holland or go back to England, but you said go back to India. It's these kinds of things accumulated and were very insulting and led to Gandhi taking action. It was very hard in South Africa, by the way, to find the writings of Gandhi, to find the material. And he said, he used a beautiful phrase, our wives and sisters and daughters, armed only with the patriotism of faith, he said, went to jail, their sacrifice being greater than our sacrifice. So that was why, in the end, I said it was a singling out of one religious faith, Christianity, Christian holidays, above others. It was the state endorsement of a particular worldview. And I said in our constitutional order, the state does not elevate any particular worldview, neither Christianity, nor Islam, nor Judaism, nor Marxism-Leninism, nor the free market, neoliberal capitalism, or any particular worldview as a state worldview to be imposed upon the whole of society. So that was Lawrence, a tiny case ending up where I said, but nevertheless, the infringement is so slight because it's a relic of a fading form of hegemony that even although it is an unacceptable endorsement, it can be justified on secular grounds. And the secular grounds are found to justify it. I didn't want this to be the first case of religious freedom, 7-Eleven being able to sell liquor on Sundays because of that prohibition. I didn't want that to happen. I said it can be justified. It reduces drinking and boozing on double holidays. And that was a secular foundation. Maybe some people say it's a thumbsuck. I'm not denying that. But it was a justification for upholding what was a very slight invasion of religious freedom. And the net result was the 4 said there's no invasion at all. 2 of us said it is an invasion, but it's a justifiable invasion, justifiable limitation. The provision banning the sale of liquor by 7-Eleven on Sundays was upheld. And just 2 Sundays later, I went to my local Pick n Pay to buy some beer, and I was told, sorry, didn't actually put it like this, but some damn fool up in Johannesburg in the court upheld the law and we still can't sell. Daniels was a case where a widow of a Muslim marriage wanted to inherit her husband's title to some property given out by the council. She was told, "You're not a wife-in-law," and writing for the majority of the court, I said, "Why aren't you a wife-in-law?" Simply because in the old interpretations given by the colonial judges and the post-colonial judges in the Cape and in Natal, there was such anti-Indian prejudice, such a colonial imperial sense of domination and hegemony of the Anglo-type worldview, that all these tribal kinds of unions and so on were not real marriages. And the interesting point of connection with the earlier discussion today was the case relied upon in the Cape courts and the Natal courts was the case of Hyde versus Hyde, heard in the High Court in England, dealing with what was called a Mormon marriage. So there's a tie-up between the discussion we heard earlier on today here. The marriage of the Latter-day Saints people was not recognized for purposes of divorce in the English High Court. That was picked up in South Africa to invalidate marriages of Hindus and Muslims in South Africa for purely racist purposes. The next case turned out to be much more difficult, the Christian education schools case. And people had come, teachers from America, finding that it was increasingly difficult to apply corporal punishment to kids in the United States. They thought South Africa was more open territory for that. And to their credit, in the apartheid days, they hit black bums as well as they hit white bums. The school was open in that respect. But it was seen as a central tenet of their religion, corporal punishment of errant boys. They didn't call it punishment, it's corporal correction. When I first read about that, I thought, claiming a fundamental constitutional right to beat children? Come on. It just seemed ludicrous. And they would hug the child, hug the boy, bend over, hit with a paddle, and hug the boy again and say it's for your own good. I found that kind of freaky. But when the case actually came before us and I was asked to prepare the judgment, I actually found it very difficult. Because it was a question of conscience. The schools had been set up by people, these were their beliefs. I'd been caned as a child at school, unjustly, for months. We didn't know about psychosexual things in those days, but for 3 months, every single day, Monday to Friday, a teacher would get me to bend over and whack my bum 6 times. I cried for the first few weeks. I decided not to cry, and I didn't cry again for about 10 years. These things have an effect on you. It was unjust, but you put up with injustice at school. You don't blub. It's the worst thing a boy can do is to blub, that's to cry. And the second worst thing to do is to split, to report on somebody. So you're learning these masculine values to sustain pain without, you grit your teeth and you don't complain. Terrible. And I heard kids, when I was locked up in solitary confinement, getting juvenile whipping, and I'd hear they're screaming and screaming and screaming. So I had a loathing, a physical loathing, horror at the idea of beating children. And yet I had this belief in conscience, importance of conscience. And how do you reconcile the two? And paradoxically, in the United States, now that comes afterwards, where in the United States, even comes now, when the question of how do you approach a law of general application, because the Education Act in South Africa under the ANC government forbade the use of corporal punishment in schools. It didn't say anything about Christian education schools. It didn't single them out. And in America, Justice Scalia, writing for the majority in the Supreme Court, said, well, that's tough luck. If the law doesn't single out a religion for discriminatory treatment, it doesn't target it, it's too bad if it's hit by a law of general application. And I'm reading the American cases, and I'm on the side of the religious groupings. I'm secular. But that's not right. That's not right. You've got to balance out the different interests involved. And you have to show there's a powerful state public interest that justifies overcoming the religious freedom that's being asserted by the particular community. I'm friendly with Justice Scalia. We share initials, AS, and we get on very well socially. We disagree as completely ideologically in legal terms as you possibly can. I think he was just wrong. And what people pointed out was, what he was saying is, it's tough luck. This is a case of peyote being smoked by Native Americans as part of their religion. And he said, that's tough luck that it hits you, it's not targeting you. But really what it meant was, it's tough luck that you belong to a small religion that's not politically powerful. Because even during Prohibition, drinking of the communion wine was not banned in the United States. You wouldn't dare do that. You wouldn't, no legislature in the United States would dare prohibit aspects of the Christian, the Episcopalian churches, of Catholicism, of Islam today, notably of Judaism. These are powerful religious groups, big voting blocks involved, but a little Native American with what was seen as an esoteric kind of religion, that doesn't really matter. That was the approach, and it became, Americans will know, a very hot issue in the United States. Congress had to intervene, and ironically, secular Albie was on the side of those favoring the rights of religious freedom as against that position adopted by Justice Scalia, who is a deeply religious person himself, Christian education. I decided in the end, writing for the court, that the prohibition of corporal correction in the relatively public domain of the school, as a generalized thing, given the rights of the child being involved, could be, in a balancing exercise, could be justified, was justifiable in an open democratic society. It didn't prevent the parents from exercising their religious relationships with their kids in the environment of the home. It didn't blot out completely what they wanted to do, provided that the correction did not exceed what the criminal law permitted in terms of chastisement. It was a difficult case, far more difficult than I'd imagined. The next case was Enver Prince. Very talented lawyer, passed all his exams, applies to be admitted as a lawyer, and the Law Society says, no, you've got 2 convictions for smoking marijuana, dacha. Peyote case now crops up again. I don't know why I felt so much for Enver Prince. They were standing at the back of the court with their dreadlocks, kind of uncomfortable. They wear funny clothing, they have long hair, and they say, why is everybody looking at us? And worse than that for me, they get up my nose. They're saying, Albie, people like you, what's the matter with you? You're so driven. Take it easy. Tomorrow's another day. Relax. They're undermining me. They're challenging me. But I just felt this guy is fighting for his beliefs. He's willing to sacrifice his career as a lawyer because of his beliefs. Are they sensible beliefs or crazy beliefs? If you're secular, all the beliefs are equally bizarre. No one is any more sensible and credible than the other. That's the way he sees the world. And it had a strong African dimension. Dacha was being smoked in this country long before the colonists came. And yet that's prohibited, and it was prohibited, research showed, because whites were worried too many white kids were smoking together with black kids. And that was the real reason for the prohibition. Before then it had been tolerated. Whiskey imported from Scotland, you can drink as much as you like and get as drunk as you like and smash up your cars and cause all sorts of damage, but dacha you can't smoke. And it was a very interesting group sociologically because they were like, I call them a diaspora of a diaspora. They modeled themselves on Jamaicans who were modeling themselves on an imagined Ras Tafari in Ethiopia. Now the Cape Townians doing something similar. But they were identifying strongly in their own way with Africa. Our court divided. 5-4 was for upholding the prohibition. We all accepted balancing was required, but the majority said that the state, even if marijuana is not a serious form of drug taking compared to other forms of drugs and so on, the state has placed it under a ban, it would be impossible to police the ban if you allowed this exemption. We said you can take the confiscated dacha and give it to the priests of the Rastafari. You can find a way if you want to, but in any event we lost. I now come to the Furi case, the same-sex marriages case. And some of you have heard the story before, but I think it is important to give the preamble to that. It's 1991, I'm just back in South Africa. I'm driving towards the center of Cape Town, and I'm sweating. I'm sweating because I'm driving with my left, and I haven't been driving for very long. I lost my arm just a couple of years before. I'm sweating because I've been in exile 24 years. I don't know the roads very well. I'm sweating because it's hot November in Cape Town, but above all I'm sweating because I'm going to go on a gay pride march. And I wish there would be a poster that says straights for gays. And then I feel ashamed. If you're going to go, you go. And eventually I see the group, I'm late, and they're marching towards me, and the first poster I see says, "Suck, don't swallow." I'm in the Cape Times newspaper tomorrow for sure. I stop the car, I get out, I run, I join. In fact, I march next to Edwin Cameron, who's one of our most brilliant judges on the Constitutional Court today. I felt so proud of myself. I'd broken through a barrier of embarrassment and confusion, and I was marching with people fighting for their basic rights and for their dignity. And we stopped at a little park, and they asked me to say a few words, and I said this issue of rights for gays and lesbians is important for a section of our community who's been marginalized and denied their rights, but it's important for the whole of South Africa. If we cannot manage difference, we are finished as a country, because difference has been used to divide us in the past, to elevate some people over others. And so this becomes a touchstone of our capacity to manage difference independently of inherited cultural and religious and other views. Fast forward 10, 15 years, 14 years. I'm sitting at the table. Pius Lange, Chief Justice, says, there's a body called Christian Lawyers for Africa are having a gathering outside Johannesburg soon. They've invited him to attend. Albie, is there anybody who can go? It's during court recess. Pius, I'm on recess duty. I don't think I'm the right person. He said, Albie, you're just the right person. And I knew what he meant. If Pius went, Pius was a Christian, a lawyer from Africa. It's a sectarian identification with the group. If I go, I'm representing the court. So a few weeks later, I'm being driven. I'm not sweating this time. It's cooler. But I'm worried. What do I say to them? I can say, on behalf of the court, welcome, have a good conference. And I think that's not right. These are people of conscience. I want them to get some sense, some flavor of what it means to have a constitutional court in South Africa. So I decided to tell them the story which you'd heard in Utah about my taking the oath, being sworn in. I'm the last one, Sachs, alphabetically challenged in those days. Since then, there's been a Van der Westhuizen and a Jacob, but then I was the last. And some of my colleagues affirm. When you affirm, you just say, I affirm to uphold the law and the Constitution. If you say, so help me God, you raise your right arm. And I wanted to raise my right arm. This was the arm of sacrifice, of struggle, of Ruth First and Joe Carby and my comrades who died in the struggle. This was the oath that I was making to the Constitution. And I told them I'd come from this very secular background. But I said, in the end, for purely personal purposes, to make the most solemn oath I could, I raised my right arm and said, so help me God. And I got a standing ovation. I felt uncomfortable. My instrumental personal purposes. But the people responded. And the next day we did a tour of the court. We built the court right in the heart of the prison where Gandhi and Mandela were locked up. It's a very beautiful building. It's an emotional tour. About 70 delegates came. And we get to the end of the tour, and I'm rushing off. I have to go to the women's jail where the Commission for Gender Equality works. I've got another meeting there, and they say, no, we must say a prayer. And some prayers are very short. Some prayers go around the world a few times, and this is one of the second, and I'm late. But I received their prayer. They were giving what they had to give. They were giving the gift of their good wishes for me in the form that meant the most to them. And I'm about to rush off, and they say we must lay on hands. Now that's quite 70 pairs of hands being laid on my secular body, but given in the same way. It was very, very meaningful to me. I mention this because later in that year, I'm asked to write the judgment on same-sex marriages. I'm not consciously thinking about the Gay Pride March. I'm not consciously thinking about the Christian lawyers laying on their hands. But I'm aware they are all part of our nation. They're all going to read this judgment. They all want to feel acknowledged and recognized in the judgment. Surely I don't have to choose which side am I on and then convert the others into losers. I have to find a way. We have to find a way. Our constitution has to be expressed in a manner that speaks to the whole nation with a coherent language that's meaningful to everybody. And in the end, the decision came down to acknowledging that to deny to same-sex couples the capacity, the legal capacity to express their love for each other, their intimacy, their mutual responsibilities in the same way that heterosexual couples can do in terms of the law is a profound denial of their dignity as human beings, completely unjustifiable. And that marriage, which means so much to so many people, to say that somehow you're undermining the concept of marriage by embracing it, is really saying you are unworthy, you are toxic, you don't belong really to humanity. Your emotions and love and passion somehow are not equal to the emotions and love and passion of heterosexuals. It's profoundly demeaning. The law must be changed to acknowledge, and we sent it to Parliament to make the correction. Within 1 year, if Parliament didn't do it, then automatically the Marriage Act, from saying I, A, B, take you, C, D, to be my lawful husband stroke wife, would add the word spouse, gender neutral, at the end. But we wanted the nation to talk. We didn't want it to be a sleight of hand kind of legal device created by progressive judges imposed on the nation. We wanted the nation to embrace what our constitution requires. It was a risky project, but the risk turned out to be not valid. The risk turned out to be fulfilled in a positive way. The nation did talk. Parliament eventually, by a huge majority, accepted a rather strangely worded law, but the law said, I, A, B, take you to be my lawful, I, A, B, take you, I, A, B, marry you, C, D. And the case of same-sex couples, that the M word kind of came in there. So that was a vindication of the rights of same-sex couples. But what about the people, Christian Lawyers for Africa? Maybe a few of them would have supported same-sex marriages, but the majority not. A very important part of the judgment dealt with the relationship between the sacred and the secular. And possibly the strongest statement in any legal decision in recent years on religion being significant for public life, not just something you can do in private, was written by Albie Sachs, the secular Albie, saying that religion is not just something you practice in private, it's part of the temper of the nation, Religion has given rise to cultural developments for many people. Their belief in human rights springs from religion. It's got enormous significance in our society. And that's got to be recognized, it's got to be respected. And we don't gain anything by saying that opponents of same-sex marriages are bigots. That was written in 2005. I'm not saying this now to be nice with the speaker earlier this afternoon. Written in 2005. And it had been written earlier by my colleague, Ari Ackerman, some years earlier as well. We don't want to divide the nation between the enlightened, that's us, and the bigoted, that's them. We don't want a cultural war. We don't want a dividing line. We want everybody to feel they are recognized, they're contemplated by, they're envisaged by the Constitution, and it doesn't help to castigate people who have a different worldview. You allow for the coexistence of different worldviews. And the very same Constitution that protects the rights of same-sex couples to celebrate their marriage in public, protects the rights of faith communities not to be compelled to perform marriages that go against their beliefs. And a suggestion was made as well, it's also apropos of what was said earlier, that in case it's certainly the first generation of marriage officers in the public sector, if their consciences prevent them from celebrating same-sex marriages, then consideration by the legislature should be given to allowing them a conscience escape from being forced to do that. And my motivation in putting that in, I've spoken about this before, it's not a secret, it's obvious, it's partly to prevent, purely to prevent martyrs, people rallying around the idea of the conflict between my faith and there's a purely, if you like, strategic basis. But it wasn't just that. I do worry about people being compelled in serving the public to go against their deep convictions, particularly if they've accepted a job long before it became an issue. And I also think, what does it mean to be married, this great moment in your life, by somebody who's loathing what you're doing? The vibes will be all wrong, to be incompatible with what you want to achieve. And I'm going to end with this now. 2 weeks later, after the law had been passed, I'm driving in Kirstenbosch. All the South Africans know Kirstenbosch. It's the most family-oriented, bourgeois place. You go for tea and scones. And I'm looking for the sign. And the sign says, "To Amy and Jean's marriage." And I felt fantastic. It was so simple. It was so simple. Amy happens to be American, Jean South African, and she said she had phoned the owner of the restaurant where they were going to celebrate their marriage to say, "Can we book for a wedding reception?" And she said, "I thought I ought to tell her." So she phoned just a day before and said, "Do you know we are two women?" And the woman manager said, "I'm so pleased you chose us. I'm so pleased you chose us." And I felt fantastic. It was just a little touch of humanity that offended nobody, that didn't interfere with the religious rights of anybody, but just allowed a little more dignity, a little more love, a little more friendship, a little more spontaneous association between people, a little more diversity in our society to become part of our reality. Thank you.